Hi, I'm Dr. Rellis. I want to give you some answers to frequently asked questions about fiancé visas. What is a fiancé visa, also known as a K-1 visa? It's a non-immigrant visa that allows the foreign fiancé of a U.S. citizen to enter the United States for the purpose of getting married within 90 days of arrival. Who is eligible for a fiancé visa? To be eligible for a fiancé visa, the petitioner, being the U.S. citizen, and the beneficiary, being the foreign fiancé, must intend to marry each other within 90 days of the beneficiary's entry into the United States. Both parties must be legally free to marry and must have met in person within the 2 years preceding the filing of the fiancé petition. What documents and evidence are required for the fiancé visa petition? Required documents typically include evidence of the petitioner's U.S. citizenship, compelling proof of meeting in person, proof of intention to marry, and supporting financial documents. Additional evidence and documentation are very often required based on individual circumstances. Can the fiancé visa holder work in the U.S.? After entering the U.S. on a fiancé visa, the beneficiary can apply for work authorization by filing Form Y-765. Once approved, the beneficiary fiancé can work in the U.S. Can the fiancé visa holder leave and re-enter the U.S.? The fiancé visa holder can leave and re-enter the U.S. on the K-1 visa. However, it is essential to ensure that the marriage takes place within the required 90-day period. What happens after marriage on a fiancé visa? After getting married within the 90-day period, the foreign spouse can then apply for adjustment of status to become a permanent resident green card holder. What if the marriage does not take place within 90 days? If the marriage does not take place within the 90-day period, the fiancé visa holder must depart the U.S. Failure to do so may result in immigration violations. We have still helped people in this situation depending on the circumstances. Can the fiancé visa holder bring dependents? Unmarried children under the age of 21 of the fiancé may be eligible for K-2 visa status to accompany or follow to join the primary beneficiary fiancé to the U.S. What if the relationship ends before marriage? If the relationship ends before marriage, the U.S. citizen petitioner should promptly notify USCIS to withdraw the petition. This helps avoid potential complications in the future. How long does the fiancé visa process take? The processing time for fiancé visas can vary, but it typically takes several months. Can the fiancé visa holder travel outside the U.S. after marriage? After marriage and filing for adjustment of status, the foreign spouse should avoid international travel until they receive advance parole. Otherwise, leaving the U.S. could lead to abandonment of the green card application. What if the fiancé visa petition is denied? If the fiancé visa petition is denied, the petitioner has the option to appeal the decision or to refile the petition with additional evidence addressing the reasons for the denial. Legal consultation is recommended in such cases. Professional legal guidance is crucial in navigating the complexities of the immigration process for fiancé visas.